Hey, Doctor, WBC 6230 2017. Kita boleh doctor.
I can have one for admission.
6230 2017.
Yeah, please, Your Lordship. The Advocate General is on way, my lord, he is coming. But let the petitioner counsel start.
Submission was virtually over. They have to submit some
Maybe
compilation.
one more minute.
We have prepared a compilation, my lord.
One more minute. Huh? Yes.
Your Lordship,
Please take your. Maybe one of us,
My lord.
myself, have already expressed a view, perhaps.
my lord.
Yes, Your Lordship decision is also, my lord, in the compilation.
Is it?
That Monica Bora decision, my lord, pertaining to Assam Cricket Association Stadium in Nahorkotia. That Lordship will find,
Page 93.
my lord. Yes, my lord, I'm so obliged. It starts from page 23,
Page 23.
page 23 onwards.
Which paragraph?
If my lord may be pleased to come to page 30, paragraph 13.1. A combined reading of Rule 5, may I read it, my lord?
Yes.
A combined reading of Rule 5, Rule 15 and Rule 16 of the settlement rules goes to show that no person can enter into possession of any government land in any area until a lease has been issued to him or otherwise a written permission has been granted to him by the Deputy Commissioner pending issue of such list to enter into possession of government land on the basis of an application submitted under Rule 5. Rule 15 of the settlement rules has specifically set forth that no person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the state government either to himself or to any other person. Then, my lord, the amended provisions, Lordship has quoted in, my lord, at paragraph 15.
Hmm. I think 19 is clear.
19, my lord, yes, there before, my lord, before that paragraph 15.1. 15.1, this is basically our argument, my lord. A conjoint reading of Rule 18.2 and 18.3 of the settlement rules makes a distinction regarding the nature of encroachment apparent. Sub-rule 2 of Rule 18 has entirely provided that when a person enters into possession of government khas land or wasteland over which he has not acquired the rights of a proprietor, landholder, or settlement holder, there is no claim of bona fide right involved, and he may be ejected or ordered to vacate the land forthwith. As per sub-rule 3, in all other cases, ejectment shall be preceded by publication of a notice in the manner. And in the compilation, my lord, we have also enclosed, my lord, decisions by the Honorable Division Bench.
19, paragraph 19.
Yes, my lord. From Rule 18.2 of the settlement rules, it is clear that there is no mandate of issuance of any notice upon the persons falling within the
But my lord.
I have to recuse. This is another one, 6230-2017.
Because, my lord, my respectful submission is that, my lord, in all the series of decisions, the emphasis is on the three categories of, my lord, persons: the landholder, settlement holder, and proprietor. If a person doesn't,
Keep for the next day.
My lord. But I was expecting a very good judgment from this one. Your lordship, both of them have dealt with this matter.
In this 6230-2017, paragraph 21.
মই যদি থাকো
21. 21 says, thus from rule 18.2 of the settlement rules and the aforementioned decisions, it is clear that there is no mandate of issuance of any notice upon persons falling within the ambit of rule 18.2 of the settlement rules.
So whether your lordship has given an opinion, does it, my lord?
Because there is precedent also
That is the
in this.
previous.
it will be a difficult situation because, my lord, my lord, the honorable judges of this honorable court has dealt with this issue.
Because on
Bearing a few, my lord, bearing a few honorable judges of this honorable court, perhaps everyone has dealt with this issue. 18.
he is one
I am always obliged, my lord.
hard Mr. P.K. Roy Chaudhary, land counsel for the petitioner. Record is his name
My lord.
and Mr. D. Hoikia, learned Advocate General, Assam, assisted by Mr. R. Borpujari, learned standing of Revenue Department. For all the respondents, post of the repetition has been placed before the division bench to decide on the issue as to whether a prior notice is necessary under Rule 18 within bracket 2 of the settlement rules, framed under the Assam Land and Revenue Regulation 1886. Because of divergent views expressed on the issue by coordinate single bench. Single bench. By coordinate single benches of this court. Para. During the course of deliberation, attention has been drawn. Attention of this court is drawn to two decisions. Rendered in WPC number 6230-2017, within bracket Jubair Ali and 67 others versus the state of Assam and others, decided on 20/04/2023 and in WPC number 6569/2023, within bracket Monica Bora and others versus the state of Assam and others, decided on 14/12/2023, wherein one of us, within bracket, Moonam has expressed a view that there is no mandate incorporated in Rule 18.2 of the settlement rules for issuance of any notice upon persons falling within the ambit of the said rule. Since a clear view has been expressed by one of us in the said two decisions in respect of the issue, referred to this bench, we are of the view that it will not be proper for this bench to hear on the issue, hear further on the issue, to stop. As such, restrict to place the petition before the Honorable Chief Justice for constituting a bench without one of us more now.
Sorry for all these 2 hours that you have spent, madam.
We have to find out whether we have expressed any view or not idea.
The written, the compilation.
The compilation of judgments placed by Mr. Borpuzari, the Standing Council Revenue, is to be kept with the case record.
I'm so obliged.
2nd of April. 2nd of April.
I'll give. When he will be available? You are ready otherwise?
I'm ready otherwise.
Who is when he will be available?
Lordship, next week,
Next week, this bench is not.
This is
Sitting.
difficult. The 2nd of April.
Fix.
First.
day after tomorrow? Day after tomorrow.
Day after tomorrow is not. Yes.
If within this week, we can fix, otherwise we'll not fix any date.
Day after tomorrow, I'm suggesting, but I think
I think
they have
he will
some.
not be available.
He'll not be available.
It is not available.
And after
Mr.
we
N.K. Borua, learned amicus brief for the appellant in 2 number is present. And MS, SH, learned additional public prosecutor for the respondent state of Assam are present. MS,
M. Kakuti.
M. Kakuti, learned counsel. Appearing for Mr. R. Sharma, learned amicus PD in item number 1. Has submitted that Mr. Sharma is out of station due to personal reason. Post-op and has prayed for adjournment in adjournment post-op as the prayer for adjournment is not objected by the learned counsel for the other sides, the office, the appeals be listed after a week on a date to expire notice.
Item 3.
Just we request the council to make the mentioned memo circulated
1 day
as
before
per the
notification,
notification.
Yes,
1 day
It should
prior.
not be the practice.
yes, ma'am.
This is not a very appreciated.
Item number 3, the council is not here, otherwise it's a very small matter, there is an eyewitness.
Harish Gupta.
Harish,
He may be available, we'll postpone it.
What?
There is no prayer.
there's no prayer. That's it, we may call it up after some time.
Okay.
But
Inform Mr. Gupta.
Pariba?
This appeal is against conviction under section 6 of POCSO Act. Lord. The conviction is of 20 years and this is against
Deceased, and he trampled him, injured him, and finally he got
It
killed.
was, it was before Deputy Commissioner Karbi Anglong,
This was
originally.
originally, yes. And the wife of the deceased is an eyewitness. Daughter is also an eyewitness, but she was not examined. Son was, although he is the informant, but he was not there in the house. So only evidence is mother's evidence, the wife's
That has
evidence.
to be
That has to be
seen.
seen.
PW.
PW1. But last line in the cross-examination, I did not see the incident. My daughter saw.
My daughter saw.
My daughter saw. But then, yes, initially she said in her examination in chief also that she did not see. But then what she further said is that they entered, the accused entered her room also. And he injured her also.
Was there any injury report in respect to PW1?
Injury report is not there, not exhibited. It might be in the case diary, which of course we cannot see now.
So that is not substantiated, that part.
That part is
That
not.
part is not substantiated. And why the daughter was not examined?
Daughter was not examined. I have to check.
She would have been the vital witness.
In the charge sheet also her name doesn't appear. Dhruva Chetri, Goma, Savitri Chetri. Savitri is.
Only 4 witnesses.
These are the 5 witnesses only.
What more is there? Let us read the evidence, Mr. Gupta.
My lord,
Let us read the evidence.
my lord.
Only one.
It can be taken after some time, Lord. After some time, Lord.
Disposal.
Only PW1 is to be read, perhaps.
Yes. But one Sabitri is there as a witness in the charge sheet. Maybe she is the daughter. We'll have to see in the order sheet why she was not examined.
Item 7. May I please your lordship, can it be passed over for time being, my lord?
No doubt.
Or
No Passover.
next week, my lord, if possible.
You're on the prayer of Mr.
EU Khan on behalf of A. Ahmed.
EU Khan Learned Counsel, appearing for Mr. E. Ahmed Learned Counsel for the appellant. You are pressing what? IA or female appeal?
I is here, my lord.
Paperwork ready, should he dispose of the appeal, right?
Our objections are also on record.
No, it's on,
Yeah, yes, paper
The-
is ready.
where's the appeal? After a week, MSS Jahan, additional public prosecutor for the state respondent that is in attendance and has no objection to the same.
Pending item number 5.
বলবো? না। Oh, apna naam. Oh.
Mr. Das, if, since other side is not available now, we can fix it as per your convenience. 5, 6. Next week, this is bail matter perhaps.
This one.
Next week you can fix
Huh.
regarding item number 6.
And 6 is, yes. NI is the main party here.
So there is no representation. We have the 6 appellant on call. Mr. Didas, senior counsel for the respondent, and I is in attendance in view of non-representation on behalf of the appellant. This is the appeal on
My lord,
Next
let it be
week?
on last of March or after Bihu.
this one for itself, since it is a bail,
My lord, that is
Adi-
March it come.
20?
Bail is not there in item 5.
Okay.
6.
6. Bail is on it. I don't.
No, bail.
That is a bail appeal.
Bail
Bail
matter.
appeal.
6, 20, 20.
Mar-
20.
My step by D. What is it?
Okay, assisted by Mr.
D Bharadwaj.
D. Bharadwaj.
Bharadwaj.
Okay.
All right, my lord.
Inform Mr. Kamar. then.
Yes.
Okay. Yes. Okay. Yes, this is fine.
This is Mr. Sohan's case. Okay. I can move. Hmm? Yes, and somebody's name is appearing here also.
Ah,
Poor day.
Yes.
Yes, Mr. Yu Khan was there.
You can't.
Yu Khan. Your name is
Sono?
appearing here.
Azad is also there. I have actually not gone into that matter, but then let him continue. I'll go through. If I cannot reply today, I'll reply tomorrow then. Huh?
Yes.
Yes, my lord. My senior, my lord, a little problem in speaking, this is why, my lord. My lord, 3 appeals, my lord, convicted, my lord, under section 302, my lord, life imprisonment.
Why is the judgment in the otherwise in a paper book?
Yes, my lord, judgment.
How many have been completed?
My lord,
3.
three appeals there.
3 appellants.
Yes,
Accused.
judgment started at page 77, my lord. Most relevant portion, my lord, paragraph 15 to 19.
No, I'll not read. I'll just trying to find out who are the person convicted.
Not you will get it at page number.
I have got it.
Yeah,
102.
100. 130.
Sabir. Farooq Ahmed,
Yes.
Sabir Ahmed,
China Weg.
Jaina Begum.
Yes, ma'am.
Jaina Begum is wife of
Appeal
Farooq.
number 1, yes.
Okay. Let us read the affair first.
Yes, ma'am. That from page one, my lord. In page one, my lord. Act, my lord, serial number 3, occurrence, offense day, 6/12/2009 at 6/6:30 AM. Information received on 7/12 at 1 PM. That is 30 hours late. Then my lord, page number 4.
Hey, here. You mean from some extent? Otherwise, yeah, available. FIR is exhibit.
My lord,
One.
exhibit 1. Start at page 4, my lord, of paper book.
My Jan, can you find out the FIR? Yeah. Let us have the original FIR.
My lord.
Sitting here for last 50 days, I have found many discrepancies in the translation.
This is the one, Lord.
Okay. FIR.
My lord, I am reading from paper book, my lord,
Okay.
translate. I am Sabiha Mahbub Chaudhary, daughter of so and so, a resident of Kanis Hile, PS District, Karimganj, have appeared in the police station and lodged this AR after getting it written as per my version. That on that around 6/6:30 AM yesterday on 6/12, while my father was going toward the pond to freshen up after getting up from the bed, the below named accused number 1 arrived there and asked my father whether he would settle the earlier land-related dispute. Hereupon my father replied to him that the mediator would settle the matter after coming back from the Hajj. Saying so, my father freshened up and entered the house. I was listening the conversation between my father and the accused number one, standing on the courtyard of our house. Then hurling abuse at us, using filthy words, the accused got hold of me by hair and dealt blow, punches and slapped me. Hearing my scream, my mother came out of the house. This is important, my lord. Hearing my scream, my mother came out of the house, whereupon accused number one slapped her too. Then my father came out of the house and he asked accused number one why he was assaulting us. The latter struck my father in the head with the hook that was lying on the courtyard. It was loud in the courtyard. Thereafter, the other accused person armed with lathi salah, it is a stick, came there and assaulted my father on various parts of his body and thus caused grievous injury to him. My father fell to the ground and became unconscious owing to the assault made on him by the accused person. Hearing the scream let out by my parents and us, the neighboring people gathered there and saw the accused person going away from there. With the help of my neighbor, I took my father to Karimganj Civil Hospital, but finding the condition of my father critical, the doctor advised us to take him to Silchar Medical College. Then we took him to the dead hospital, but as the condition of my father was critical, the doctor advised us to take him to the neuroscience hospital, Guwahati. Thereafter, my mother and brother took him to Guwahati. At present, he is undergoing treatment and nothing can be said about what may happen to him at any moment. The name of the witnesses will come to light in course of the investigation. Since we were busy in attending to my father, there has been some delay in lodging this ejaar. I therefore pray to you to necessary step in this regard by investigation and matter of life. This is the affair.
What was who was the victim? Masuk Ahmed Chaudhary.
Yes, ma'am. My lord, as per the FIR, the daughter and wife also sustained injury, but my lord, they did not go to the medical or got themselves examined. So only the victim.
Who is the deceased victim? Masuk Ahmed Chaudhary.
Yes, madam.
When did he die?
He died after a week, my lord.
What is the date?
On 12th, my lord. 12, after a week.
Where is the charge sheet?
Yes, madam. That's it, page 121. Prosecution side, my lord, examine evidence of 9 witnesses, including 2 doctors.
Official,
Hmm.
she is not official. Why is it? Commitment order?
Commitment order. Page 8, man. Commitment order.
What happened to the 4th accused?
My lord, 1, my lord, found juvenile.
One was juvenile.
Yes. And 3, my lord, tried and before you lost.
Okay, who was the juvenile? Juvenile. Okay. 20. Iqbal Ahmed.
Yes, ma'am.
Okay. Okay, he was the son.
Yes, my lord, son.
Son of this
Many-
appellant number
many-
1 and 3.
Yes.
Okay. Now let us see the charge framing order.
At the page 7, ma'am.
P54
354, ma'am.
and 302.
Yes.
Red with 34.
Yes.
Okay. Oh, Mr. Kama,
My lord.
your case is Wednesday, next Wednesday.
Yes, my lord, but today I have another case, my lord. Actually, I'm told item 6,
And that is what?
Nia criminal.
Yes, yes. Das was available.
My
Das
lord.
was available.
Yes, ma'am.
And I,
Yes, my lord.
You
I was
were
also
there.
there, my lord. My junior, I don't know, my lord. what they-
nobody came up.
My lord, I pray, my lord, this should be taken up, my lord.
We
I'll
have
solve it.
started now and this code
No, no,
will
him be.
be rising at 2:45.
Yes, my lord.
I don't know.
Then, key date, that's fine. No?
Wednesday, next Wednesday.
20. That's okay. Thank you.
But because since this case is started
Yeah, no, I do
and
understand.
this code will be rising at 2:45, I
2:45,
don't
yes,
think
sir.
there is any possibility. Yes.
My lord.
Now,
Now, my lord, PW is my lord.
PW.
Yes. Just start, my lord, page 9. Page 9, PW1. Sabiha Mahbub Chaudhary.
Bit louder, Mr. Sohan.
Yes, Sabiha Mahbub Chaudhary. She is the daughter of the victim, my lord, and she is the complainant, informant.
Okay.
So, my lord, chief, my father is the disease of this case. I am complainant. Exhibit 1 is my jar. Exhibit 1 is my signature on 6/12/9. At about 6:30 a.m., my father went out from our house for washing hand in the pond. At that time, Farooq Ahmed came there and asked my father as to why my father did not solve the land dispute with them. In reply, my father told that the matter may be resolved after returning of the middleman from Hajj. At that time, I was near to my father. My father returned back to the home. At that time, the accused Farooq Ahmed, uttering slang languages, rebuked me and also assaulted me with fists and blows. Hearing my alarm, my mother came out and tried to resist them. The accused Farooq, Sabir, Iqbal, and Jaina began assaulted my mother. Hearing on alarm, my father came out. At that time, accused Farooq Ahmed from backside with a spade assaulted on the head of my father. As a result, my father fell down. Hearing alarm, neighboring people started together to PO. Before assaulting my father, accused Jainal gave the spade to accused Farooq who assaulted. When people started to come near to the PO, accused Iqbal restrained them with threatening that in case they came near to the accused, they would be assaulted. After that, the accused person fled away from the PO. I told the entire incident to the neighboring people who came to the PO. My brother also came. After that, my uncle Abul Hussein, cousin Kamrul Jaman, aunt Badrun
Is
Nisa,
any of these witnesses PW?
PW1 man.
No, that is PW1.
Yes.
But these names,
Name my lord,
this name,
Sabiha Mahbub Chaudhary.
who is her mother?
Is my lord, she the daughter of the victim.
No. Who is her mother? What is the name?
Mother, but PW2 is the mother.
1 minute.
PW2 is the mother.
1 minute. 1 minute.
Yes.
Mother is PW2.
Yes, my lord.
Now, page 10, the portion you are reading,
Yes, ma'am.
this Abul Hussein, is he a witness?
He's another uncle.
Yes, ma'am.
No, he's
Abul Hussein,
not a witness.
Not a witness.
Hussein, not a witness. Abul
and
Hussein,
this cousin Kamrul Jaman,
Kamrujaman, my lord,
Yes, he's a witness. 6.
yes, 6, yes.
Kamrul Jaman,
Yes, ma'am.
is
And
PW6.
Badrun Nessa also, my lord, PW5.
Bodrun Nessa,
Yes, my lord. Imrana, PW4.
Imrana,
Ma'am.
PW4.
4.
Okay. I read. After that, my uncle.
Yes, yes. Well, I began along with other came when I reported the matter. My father was taken to Karinga Civil Hospital for treatment. I was also along with my father. My father was referred to Silchar Medical College and Hospital, Silchar. From Silchar, my father was taken to JNRC Guwahati. There at JNRC, my father took treatment for 5-6 days and expired. I lodged the Azhar on the following day of the alleged occurrence. At that time, my father was taken to Guwahati. During investigation, police visited PO and seized the spade and one wood pitch. Before my lodging of Azhar on the date of alleged incident, the accused person lodged Azhar against us.
1 minute.
So
But-
there was
1 minute.
yes.
Okay, before my lodging FIR,
Yes. Yeah.
the date of, you lodge the FIR.
Yes, my lord, there is cross case, it appears so. My lord, before my lodging the ejar on the date of the alleged incident, the accused person lodged ejar against us, and which police visited the PO and seized the articles. So, my lord, and in the ejar lodged by appellant side, police seized the articles.
Hmm.
Exhibit
Yes,
2
lodge
is,
the seize the article.
yes,
Exhibit,
Two
this
is-
exhibit two
my lord. Just
is a seizure list pertaining to this case or that case?
my lord, shown in the present case.
Huh?
Shown in the present case. But my
What
lord,
is
statement
language?
says that, my lord,
It's in this case, not in
Huh?
the cross case.
So on the date of the alleged incident,
Mm.
the accused persons lodged the ejar against us.
Hmm.
And for which? Police visited the PO and seized the articles.
yes.
For which?
For which?
Whether
That
it is
shows-
correct or not?
That shows it is in the other case, but
Huh?
41st FIR.
That is what I am asking.
First FIR.
In the first affair, that is by accused person.
Hmm,
Let us see the seizure list.
gotcha.
Let
It
us
will,
see.
be- it will be, yes.
Oh,
yes,
in the here it is.
Yes, yes.
If it is available here.
Yes, yes, legally.
108.
108.
Let us see. What is the police case here?
This is police station case number. And this is
524.
Ah.
It is shown as 524 only.
524 only. Shown by the complainant and other witness in connection with the above reference case.
Huh?
And it is the whole, which was
7, 9. See that. What was seized? Kodal.
One
the
hook,
whole, which was used in the present case.
108, right?
Hmm.
108.
108.
and my lord also mentioned a piece of wood.
Oh,
A piece of wood and a piece of wood.
see,
That piece of wood can be in relation to the
Because-
other case. But
this
cross cases.
line, this
Ah.
line, the seizure is made on 7/12/2009.
Hmm.
This was perhaps incorporated later on with a different ink.
Hmm.
I have seen the
The
original one.
original.
This just below description of seizure,
Hmm.
a hoe,
Yes,
below that the seizure is made on 7/12/2009.
yes.
Yes.
This is with a different ink.
Ach-
Then the inks in the other.
Earlier
Part.
version. Cross cases cannot be dealt together. It
But-
has to be separately done.
But
No, not there.
perhaps the case number.
Cross case to why not?
Whether case was registered, the other case.
Other case, my lord, from the evidence it is shown.
Oh, according to my information that it is, it ended in FR, final report.
FR. Okay.
Oh, no? Oh, judgment is reflected, I'm told.
Hmm?
It is reflected in the judgment. What is it? There are 7. Put account. You tendered in FR, acha. Our lordship will see at page number 86 of the
86.
judgment. 86. Accused person lodged a criminal case against her which ended in FR.
86.
First 3 lines. Narazi
Wow.
case was filed. Summon they appeared, which is pending before this court. Acha, acha.
Okay. Okay. Exhibit 2 is the seizure list.
Yes. Accused to the seizure list, 2-1 is my signature due to assault of the accused Farooq and Sabir Ahmed. I sustained swelling injury, but due to the seriousness of my father, I could not take any treatment for the injury. Cross person, my lord. We got bail in the cross case filed by the accused person. I adduced evidence against Iqbal before the Juvenile Justice Board, Karimganj. At the time of taking of my father to Karimganj Civil Hospital, I was along with my brother Ahmed Raja Chaudhary, uncle Abul Hussain, Abdul Wahid, and many other people. But I cannot say how many people were with us.
Abdul Raja Chaudhary is PW3.
Raja Chaudhary.
Is PW3?
My lord, yes. Raja Chaudhary, yes.
Uncle Abul Hussain. Abdul Wahid. They were not witnesses. Okay. PW. Okay. To my father. Yes. Abul Hussain, Abul Wahid, and many other people.
I cannot say how many people were with us. We took my father by an auto rickshaw. The doctor talked with my brother about my father about 6:45 a.m. We reached the Karimganj Civil Hospital. At 8:30 a.m., my father was released from Karimganj Civil Hospital for seizure. My brother, my mother, and other some persons went to seizure with my father, but I did not go. I returned home along with my uncle Abul Hussain. On that day, I stayed in my house. Many other relatives came to my house and inquired about the incident. On that night, I did not go out. On the following day, I came with my relative and filed the case. Ejahan was written by one Mohori. Petition writer at my residence. I did not get any police station on the way. Now I am studying in BA second year. At that time, I used to study in MMMC Girls Higher Secondary School. I always used to attend school from my home. Accused Farooq Ahmed is my own uncle
Okay.
and Iqbal is his son.
So Farooq is your uncle.
Yes. His uncle,
Zaina is your aunt.
mother.
And what about Sabir?
Is the son of him? He is the son nephew.
Yes.
He is the
Sabir,
son.
Sabir.
Sabir, yes.
Who
He
is
is
he?
the son.
Huh?
Son of Farooq.
Not, I think Iqbal is.
Iqbal is also a son. He might be younger.
Huh?
Sabir is the son of Farooq.
Mhm.
Farooq. Because in the appeal memo, I have seen
Farooq.
somebody else's name is there.
Lordship will say, appeal memo, father's name is reflected as Farooq.
Appeal memo, let us see appeal.
Page number 139. He is the elder son of Farooq. Iqbal is
Okay,
the younger.
Okay. Okay. Sabir is son. Okay. Yes.
Yes. I did not see Farooq Ahmed in Karimganj Civil Hospital except the earlier name witnesses about 30.
Which part you are reading?
My lord, I am reading page 11, my lord, after 7, 8 line, my lord.
One, read from third line, the accused
Yes.
persons reside.
Yes, accused Farooq Ahmed is my own uncle and Iqbal is his son. I have two uncles, namely Abul Hussain and Farooq Ahmed. The accused person reside along with us in the same campus and backside of our house. There is a pond used by all. At the time of the alleged incident, the accused persons also went to the ghat for washing faces. I had no knowledge whether Farooq Ahmed sustained any injury. I did not see Farooq Ahmed in the Karimganj Civil Hospital, except earlier named witnesses about 30, 40 persons gathered at the pew. At the time of reporting about the incident to my nearer persons, all of them heard about my reporting. The accused person had a prior intention to assault my father and also made several attempts to assault my father. My father filed a charge against the accused person. It is not a fact that the accused Farooq Ahmed did never make any attempt to assault my father, and my father also did not lodge any charge against him. I cannot say how many blows were inflicted by the accused. I am younger to my brother. I cannot say who lifted my father from pew. It is not a fact that we reported to the doctor of Karimganj Civil Hospital that it was a case of accident. On 7/12/2009, my father was admitted in GNRC. I cannot say whether in GNRC cause of injury was reported as accident. It is not a fact that at the material time of the alleged incident due to scuffling between the both my father and accused Farooq Ahmed, my father falling on the side of the pond sustained injury and accused Farooq Ahmed also sustained injury similarly, and he was also hospitalized at Karimganj Civil Hospital on the same day. I was in the house when the police visited our house. My grandfather showed the place of occurrence to the police. The police, after hearing us, asked us to lodge complaint. So police asked them to lodge complaint. My grandfather handed over the spade to the police. If you kindly see, my lord, his grandfather handed over the spade to the police. And he was not examined, my lord, as witness. And similarly, wooden piece of lathi was also handed over by my grandfather. So both the material, my lord, weapon, my lord, of offense handed over by grandfather to police. Blood stain mark was in the spade. Police seized the same on the following day of the occurrence.
Where is the seizure list? Let us, how many seizure lists?
Only one seizure. Exhibit
Huh?
2. Exhibit 2.
Exhibit 2.
Yes, ma'am. Page 108. 108.
Oh. Hoe and spade is same. Or what?
My lord,
Spade are same.
Almost.
Who is not spade?
Hmm?
Who is the spade?
who, my lord, in SMS we call Kudal. And spade, my lord, maybe Kudal, it may be Belcha also.
Of same genus.
Same
Ah,
genus,
yes.
same genus.
Okay.
My father
So,
was,
that lathi was not seized.
Lathi was seized, my lord,
Huh?
wooden piece. My lord, page one.
Okay. Seal number 1 and 2 both.
Yes, in,
108.
yes,
Piece of wood.
piece of wood, yes.
Piece of wood. Okay.
And that were handed over by grandfather of the informant, and he was not examined. Blood stain mark was in the spade. Police seized the same on the following day of the occurrence. My father was directly taken to the Coronment Civil Hospital. I cannot say number of injuries sustained by my mother. I cannot remember the date of recording of my statement by police. The ghat of the pond was pakka. About 8 number of staircases are there in the ghat, having depth of about 6 feet. It is not a fact that I was not present at the pew at the time of alleged incident. It is not a fact that my father sustained injury by fall in the ghat. And for that, I did not lodge any hazard and subsequently being influenced by others lodge hazard on false implication. So, my lord, there was suggestion by the defense minister. It is not a fact that I and my mother were not assaulted by any of the accused person. Blood came out from the injury of my father, which fell on the ground, keep the place of around 1 cubic, which was shown to the IO. It is not a fact that I did not state before the IO that after the alleged incident, when police started to come near to the PO, they were restrained by the accused persons. It is not fact that I did not state before the IO that accused journal handed over the spade to the accused Farooq Ahmed. It is not a fact that I adduce false evidence. It is also not a fact that my father inflicted injury on the person of accused Farooq Ahmed. It is not a fact that I did not state before the IO and about Abu Hussein, Kamal Jaman, Badrul Nesa, Imrana Begum, and many other came just after the incident.
Yes.
Then my lord PW2, Musammad Sajeda Begum Chaudhuri. Is the wife of the victim, page my lord 13. I know all the accused person. They are my near relative as we reside in the same homestead. On 6/6/12 at about 6:30 a.m. when my husband went out for washing mouth in the nearby pond situated at the backside of our homestead. Accused Farooq Ahmed, my husband's younger brother, asked my husband for demarcation of land. My husband replied that on return of the middleman who went to Hajj, the matter would be decided. At the time, I was near to my husband on the door. Hearing conversation, my daughter Sabiha Mehboob Chaudhuri also came. At the time when my husband went to return back home, accused chased my husband, uttering slang languages. However, my husband entered into the house, but accused finding my daughter started to assault her. Seeing the same, I went out of the to resist the accused Farooq. Then all the accused person, namely Farooq, Sabir, Iqbal, started to assault me. Seeing the same, my husband came out to save me. Then accused Jaina Begum came there with a spade. Accused Farooq Ahmed with a spade inflicted hurt on the head of my husband. He then fell down. Other accused persons with spade, lathi, bamboo, stick, wooden piece, assaulted my husband. Hearing hue and cry, my son Ahmed Reza came out. Seeing him, accused person went away. Hearing hue and cry, other member of our homestead came to view. There, namely Abul Hussein, Kamru Jaman, Abdul Wahid, Imrana, Badrun Nisa, Abdul Khalik, and many others. My husband was taken to Karimganj Civil Hospital after preliminary treatment. He being referred to the secretary of SMCH, Silchar. I went with my husband to Silchar. After some treatment, my husband was referred to GNRC Guwahati. Accordingly, he was shifted to GNRC Guwahati. He was there for about 1 week as an unconscious condition. And on 12/12/9/2009, my husband succumbed to injury JNRC Guwahati. I was with him till his death. During treatment, JNRC, my daughter, PW1 lodged a to Karimganj case. PM examination of my husband was performed in GNRC. This part is not correct. In my present inquest was done, and my son and my maternal uncle-in-law were also present in the hospital. Dead body was taken back to our residence at Karimganj. I gave statement before the IO of this case. I could not know while we were busy with the treatment of my husband, shifting one place to another. Accused person lodged a criminal case against us. In that case was ended in FIR. Subsequently, Naraji case was filed, and being summoned by London magistrate, we appear. This case is now pending before the dispute. Now, cross my lord. During investigation, I gave a statement before the magistrate under section 164 CRPC. Exhibit 3 is my statement.
This is wrong then, in the index, serial number 20, victim, guard, I don't. This is PW2.
Yes, my lord. Not,
Index,
not
informant 164 is not there.
one. No.
It is
Ma-
this
ma-
PW2's
Yes.
164.
Mother, yes,
Okay.
of her mother. A cross person, my lord. After 40 days of alleged incident, I gave a statement before the magistrate. So, my lord, is after 40 days. I did not give any statement to police. This is also important, my lord. I did not give any statement to police. On the southern side of our homestead, the homestead of Habibur Rahman and Abdul Wahid are situated. I cannot say in which side the house of Khalil Master and Munna Das situated. I do not know Mudaris, Majid, Abdul Khalik, Burhan Uddin. I heard their name. It is not a fact that their houses are situated just adjacent to our homestead. On the western side of our homestead, there is jungle, and there are some houses on the western side of the jungle. I, after the incident, did not come with my injured husband either to hospital or to the PS. However, I went with the injured GNRC Guwahati. There I was asked about the cause of injury. At the time of deposing evidence, it is noticed that sometimes the witness burst in tears. There my husband was under treatment for 7 days. My husband was admitted in intensive care unit, ICU. My daughter informed me that accused person had already filed EJAR. After that, my advice, my daughter lodged the EJAR. So my mother advised the daughter to lodge EJAR. There was no altercation. This is my lord important. There is no altercation. I did not hear any altercation. No outsider were present at the time of alleged incident at the place of occurrence, except the family member of both sides. The entire incident occurred while the time of 5 to 10 minutes after the incident, 30 to 40 villagers assembled at the place of occurrence. I did not notice whether any family member of Abdul Wahid, Khalil Master, Majid Ali came to the place of occurrence. My husband was lying injured at the place of occurrence for about 5 to 10 minutes. First, my son and my husband's younger brother, Abdul Hussein, lifted my husband. After the incident, I informed all the gathering people about the cause of injury, but I cannot say exactly the name of all the persons from I reported. Accused in a spur of moment inflicted the injury. Accused in a spur of the moment inflicted the injury. I did not get any scope to restrain him. I was not examined by doctors. Entire incident of the attack took place within a period of 5 to 10 minutes. I did not count the number of blood spots. I cannot say whether accused Farooq sustained any injury or not. It is not a fact that I did not state before the IO date. At the time I was near to my husband on the spot. Hearing conversation, my daughter Sabia Mehboob Chaudhary also came. At the time when my husband wanted to return back home, the accused chased my husband uttering slag languages. It is also not a fact that I did not state before the IO that seeing the same, I went out to resist the accused Farooq. Then all the accused person, namely Farooq, Sabir, Iqbal, started to assault me, and seeing the same, my husband came out to save me. It is also not a fact that I did not state before the IO that when my husband fell down, other accused with spade, lathi, bamboo, stick, wooden pitch assaulted my husband, and hearing hue and cry, other members.
161 statement is not marked, was not marked.
Yeah.
Previous statement of this PW2. Now, were they available or not? Because he said police did not record her statement.
We have to see, because after 40 days, even PW3 was examined by police after 40 days. So perhaps after 40 days, I'll see the case diary. It will be recorded, and contradictions are there. Contradictions are proved. So it was recorded. PW2's contradictions, she stated somewhat differently before the police, it seems.
No,
Yet to go to the
one
police.
thing in page 15, right?
Yes.
Page 15
Hmm.
of the paper book, cross examination
Yes.
part,
Huh.
second line.
Yes.
I gave statement before the magistrate,
Magistrate.
but I did not give any statement to police.
Police.
This is one part,
Yeah, this is one part.
right?
Yes.
If it is not there,
Hmm.
so there cannot be this contradiction.
And there cannot be this contradiction. But I think
That you just find out, check out, because I will not take the trouble.
Yes, yes, of course, I'll do
Why
it.
should?
But
If it is not there even, then this is not a contradiction.
police must have also said,
Please see the case, the
uh,
video.
police's statement shows that she had made statement.
Let us see.
Not. I did not give any statement. After 40 days, I gave statement.
But that statement is not marked.
Statement is not marked. Normally, it is not marked.
If it is not marked, what is the value? What can be attached to contradiction?
Yes, in fact, V.K. Mishra's case, Lordship knows how to prove contradictions. But marking of the 161 is not done in our state. I have not seen.
But that is the law.
In one of the very earlier case, I found 161 statement has to be exhibited. And then the contradiction has to be proved.
Yes.
But it is not done in, I have not seen in our state.
So,
It is not exhibited. But again, if we see V.K. Mishra's case, contradiction is proved in the way it is
no, it is
being
not
held.
marked at least.
It should be marked, it should be exhibited, but
Yes.
it is not done.
So,
But that will not be
it's a
fatal.
consistent view.
No,
That
if,
is a consistent view. Suppose it is not a fact. I did not state before the police.
Yes.
That stays in the realm of suggestion.
Yes.
But if it is marked and exhibited, that this is your statement, previous statement,
Yes.
mark D. suppose.
In this case,
And that is to be put before the IO.
yes.
See whether this lady had stated before you in this manner. He will say that no, mark in the exhibit. D.
Yes.
She did not state. Then this part can be taken into account subject to your submission or otherwise this is simply a suggestion. Basically, it is a defense case, but it is not contradiction. Whether I am correct.
No, I mean, if we go through V.K. Mishra's, of course, that is
Only became so. There are others.
so many. Normally, it is not done. That will not be
That is
fatal.
the law.
But it will not be fatal. I don't think so because the judgment that Lordship must also be referring to, there it is said 161 has to be exhibited and that it is to be placed.
One thing, if I remember, one is contradiction by diction. And the other is contradiction by omission. What is not there cannot be incorporated, right? So if she did not state, it would be not there.
It will not be
Right.
there.
But contradiction by diction, suppose in the before the witness box, he said he came with a pistol. But in a 161 statement, it was a knife. That is contradiction by diction. But whatever was not said in the 161 statement, that Mr. Sohan, Mr. M.S. Jahan, Mr. Ahmed was there. She limited to only 3% came. But in the witness box, she named more, 3.
Yes.
If those are exhibited, then it is a contradiction plus exaggeration.
Particularly in this case, it should have been done.
She said it is also not a fact that I did not state before the IO. Meaning thereby there is a statement.
There is a statement.
Now, this part is to be put to the IO also.
It was put.
But merely putting will not
Yes.
will do.
Will do, I think, because
That your submission will not do.
no, I'll be backing my submission with some
Your submission will not do.
because
It is the authority which will do. Rate 145,
yes,
155.
154.
Those will do.
Yes,
M.S. Jahan's submission will not
will
do.
not do.
Right?
But I'm backing my submission with V.K. Mishra's case because there it is said whatever she says to the police has to be put to her, and then if she says I have not stated,
Seems to be.
shown to her is not there.
Yes, there are
It has to be put to her.
BK Mishra,
Lordship will just, I'll just see.
BK Mishra. It is to be marked.
It
What
has
does
to
it
be,
mean marked?
it has to be marked
BK
perhaps.
Mishra, what? BK Mishra, what is to be marked then?
Huh,
If BK Mishra is correct,
huh,
as per your submission,
yes. Lordship perhaps at this 2007 case.
2059 SSC.
Ah, yes.
Hmm. See,
Lordship.
it becomes the duty of the trial court to ensure that the part of the police statement with which
Hmm.
it is intended to contradict a witness
Hmm.
is brought to the notice
Brought to
of
the notice.
witness in his cross-examination.
Ah, yes.
The attention of witness is drawn to that part.
That part, that part. That of course,
Merely
that,
putting a suggestion will not do.
that part. of
This
course.
must be reflect in his cross-examination by reproducing it.
Huh,
Reproducing it.
reproducing it.
If the witness admits the part intended to contradict him, it stands proof.
Huh. Part
That
means,
part.
means the statements which are there. Perhaps.
This is
that's-
everything will go, Tehsildar will go away. If he denies having made that part of the statement, his attention must be drawn to that statement and must be mentioned in the deposition.
Hmm,
By this process, a contradiction is merely brought on record.
hmm.
Brought on record, but it is yet to be proved.
Yet to be proved.
After when investigating officer is examined in the court, his attention should be drawn to the places marked for the purpose.
Lordship,
Madam,
Lordship is
This
reading.
part for the purpose
Huh.
of contradiction. This has to be exhibited.
This is to be, this is what I know. This has to be exhibited. But it's not done. I
Otherwise,
mean,
my theory which I have learned,
but Tehsildar Singh's case, I think, I don't think so.
Tehsildar has, from Tehsildar,
Uh-huh.
things have progressed.
Progressed, yes. Hmm.
We are not into Tehsildar now,
Mm.
58.
Hmm.
Things have progressed. Thereafter, all this, very recently also, many other.
Many.
I can give you at least 10. If
Hmm,
you
there are
give
so
me a
many.
1 hour time,
Hmm.
sitting here it is not possible, but I can, but this is to be marked.
Lordship has read which paragraph? Lordship, even I
Same
have.
paragraph,
No,
continuation.
I mean the marking thing.
You go on,
Marking, marked, of course, during the trial. Yes, it has to be
should be
marked.
drawn to the places marked for the purpose of contradiction. It will then be proved in the deposition of the investigating officer, who again by referring to the police statement will depose about the witness having made that statement. The process
Witness
again involves referring to the police
and
statement and
this-
culling out that part with which the maker of the statement was intended to be contradicted. And if the witness was not confronted with that part of the statement,
His
with which
attention should
this
be
part
drawn
for the purpose is the,
to the passage marked for the purpose of contradiction.
because
Marked
we,
for the, yes.
madam, statement may run into 100 pages.
That has to be marked again.
That portion has to be marked,
Yes,
brought to the notice,
brought to the
to
notice.
be exhibited. That will not prove
Mm.
contradiction.
Mm.
But again, it has to be put to
Placed
the
it
IO.
before the IO.
See, this exhibit remark was her previous statement you recorded.
Mm.
Yes,
Mm.
and it will prove the contradiction.
Mm.
Otherwise, this is in the suggestion part.
But this is in the
This
cross-examination.
is suggestion, it is maybe a case of defense.
But it is in the cross-examination only. Because
Cross-examination,
Huh.
where is the marking?
marking is, Doctor will see that part is in inverted comma. Perhaps that will suffice. Doctor will see. PW2, it is not a fact that so and so.
It is
I did.
say in the page 15,
Huh.
last paragraph,
It is not.
is not fact.
Mm,
I did not state
mm,
before the police,
Mm.
IO,
mm.
that at that time I was near to my husband
On
on
the-
the door.
Yes.
Now this will be omission,
This can be an omission. Yes.
right?
Yeah. Yes.
This omission,
Mm,
there are two things I have said, omission and diction.
mm,
This part that she has not said,
mm.
whether this can be proved without marking the portion. Because see,
Mm. No, marking, the lordship is correct. It may run into 100 pieces. Marking has to be done.
no,
Which part?
whatever, if suppose one thing was not said at all,
Huh.
you will not find it,
Enough. It is.
right? This is omission.
Mm. Now, what contradiction may amount to omission is again another
No,
thing.
two examples I have given.
Mm,
One, that you said knife,
mm,
but in the witness box, you said about pistol.
Mm.
That portion can be easily marked.
Yes.
So
Because
she
it's there.
stated in the chief
It's there.
that he brought a pistol,
Huh.
but in the
Yes.
cross-examination, you'll put her,
Mm,
see, in your previous statement, you have said that the man brought a knife.
Mm.
Then she will deny.
Mm.
If she admits,
Then proof.
no issue.
Yes, proved only.
It is already contradiction.
Contradictory.
If it is, she denies,
Mm.
then portion has to be marked,
Yes, marked and
exhibited,
to the IO.
exhibited.
Mm.
Then you have to wait for till IO,
IO.
and you have to put it to him. Then it will be contradiction. Then this reliability of the witness to that part at least is shaken,
Yes.
right?
Mm.
Now here, in the other side, suppose he did not stay,
Then it's not there. So what marking and all?
then also it is to be marked.
No, not
Mark.
that. No, the entire statement, whatever is against, whatever is contradictory,
Okay, we'll see to that.
lordship. We'll see whether her statement was recorded.
You find out.
I get it. Enough. Study done has.
27. Who is the IO?
IO PW9, man.
9 or 8?
Eight. Sorry, my lady, 8. 9 is doctor.
Hmm?
8 is IO, 9 is doctor.
8 is IO.
8 is IO. Page 27.
Page 27.
Yes, ma'am. Should I read my lord IO?
কালি যে ডাঙৰ এটা দিছিল নহয়, ডাঙৰ এটা দিছিল মানে নেপাৰ নিশ্চয় এটা মেইন কি হয় We'll come back, Mr. Chauhan, 5 minutes.
Her 161 was recorded on 3rd of February.
The incident was of July.
No,
July, perhaps.
no, December,
December
12/12 or 6/12.
6/12.
In a very recent judgment, Munna Pandey, it was a duty rendered on September 4, 2023. Three judges. Three judges. Authored by Justice Padiwala. It was a duty of the defense counsel to confront the witnesses with their police statements so as to prove the contradiction in the form of material omissions and bring them on record. We are sorry to say that the learned defense counsel had no idea how to contradict a witness with his or her police statements in accordance with section 145 of the Evidence Act. The lapse on the part of the public prosecutor is also something very unfortunate. The public prosecutor knew that the witnesses were deposing something contrary to what they had stated before the police in their statements recorded under section 161 of the CRPC. It was his duty to bring to the notice of the witnesses and confront them with the same, even without declaring them as hostile. And it has gone on describing 161, 162. Then PK Mishra was discussed. Right. Then para 50. What is important to note in the aforesaid decision, I think PK Mishra. PK Mishra.
Yes. In fact, I stand corrected. I've seen the VK Mishras again. VK Mishra, it is said that first they have to be confronted with that part and that has to be reproduced in the cross-examination. Perhaps that part within inverted comma has to be,
Quote unquote.
has to be given in the
And
cross-examination.
it is to be out of that portion is to be marked.
Within inverted
Now,
commas.
what is important to note in the aforesaid decision of this court is the principle of law that if the witness was not confronted with that part of the statement, with that part of the statement with which the defense wanted to contradict him, then the court cannot suo motu make use of the statement
Cannot make use.
to police not proved in compliance with section 145 of the Evidence Act. Therefore, it is of utmost importance to prove all major contradictions in the form of material omissions in accordance with the procedure as established under section 145 of the Evidence Act and bring them on record. It is a duty of the defense counsel to do so. So just because it is in the form of suggestion, isn't it? This part.
In other cases, I've found they put it in inverted commas, all those, the entire part. Because what I can see from VK Mishra, it has to be reproduced. Thereafter, that witness has to be asked whether you have stated.
You
If she
admit,
says,
whether you admit this, whether you have made this statement,
yes.
right?
She says yes.
Yes.
End of the matter.
End of the matter. But if she denies,
If she denies, then it will go.
that it will be to the IO, put to the IO.
Because that word is very specific, reproduced. Lordship can go to the VK Mishra's.
Yes.
Yes. It is, while recording the deposition of a witness, it becomes a duty of the trial court to ensure that the part of the police statement with which it intends to contradict the witness is brought to the notice of the witness in his cross-examination. The attention of the witness is drawn to that part, and this must reflect in his cross-examination
That
by
part.
reproducing it. Yes,
That part.
that part.
That part means that part of the statement.
That part of the statement.
And this must reflect in his cross-examination by reproducing it.
Reproducing it.
That will be quote unquote.
Quote unquote.
That
Every
is the
day
way
is a learning
mark-
day. In fact, I had skipped this.
This has to be marked
This has to be marked.
by exhibiting.
Ah.
Exhibit A, B, C, D, whatever.
Yes.
Then this part is to be put to the IO.
Yes.
If this
Mm,
witness
mm.
does not admit it, denies that I did
I have
not
not
make any
stated.
statement.
Yes, yes.
But otherwise, this cross-examination of PW2 in this
Two.
case
Huh.
is merely a suggestion.
It's a suggestion. It's the second part. The first part they have left out.
Okay.
Lordship.
Similar manner it was put.
Huh.
Oh, I have seen page,
Yes. Yeah.
page.
Yes. He said she did not say.
I think it's 30.
Yes.
It
30.
is similarly put.
Sajida did not state before me at the time of incident. I was near my house.
But it was not marked, not by exhibited. But value is to be attached. Court
That,
cannot, now court cannot see that statement.
That contradiction is not proved according to the law.
Then what will remain? The chief part.
Chief part. It will go in favor of prosecution now.
Perhaps.
Perhaps.
Yes, Mr. Chauhan, where were we?
My
Page
lord,
15, last part.
page 15, last part, yes.
Read from last paragraph. It is not fact.
It is not fact that I did state before the IO that at the time was near my husband on the door. Hearing conversation, my daughter Rabia Mehboob Chaudhary also came. At the time when my husband wanted to return back home, the accused chased my husband, uttering slag language. It is also not a fact that I did not state before the IO that seeing the same, I went out to resist the accused Farooq. Then all the accused person, namely Farooq, Sabir, Pal, started to assault me, and seeing the same, my husband came out to save me. It is also not a fact that I did not state before the IO that when my husband fell down, other accused with spade, lathi, bamboo stick, wooden pick, assaulted my husband, and hearing him cry, other member of the home state, namely Abdul Hussain, Kamrul Jawa, Abdul Bari, Imrana Begum, Badrul Nesa, Abdul Khalik, and other came to the place of occurrence. It is also not a fact that my husband entered into the house, but seeing accused person to assault my daughter, I went out to the resist the accused, and seeing the same, my husband was also came out. It is not a fact that alleged incident occurred in the ghat of the pond of our homestead, and there had been scuffling between the accused Farooq Ahmed and my husband. As a result, my husband fell down on the pumic stone of the ghat and sustained injury. It is not a fact that at that time I was not in my house and local people brought my husband along with the accused Farooq to hospital for treatment. It is not a fact that I stated before the doctor of JNRC Guwahati that my husband sustained injury in an accident. Doctor did not ask me to the cause of injury. It is not a fact that prior to the alleged incident, on 2 occasions, my husband was operated by doctor at Guwahati. My husband, about 3-4 months prior to the alleged incident, took leave on medical ground. It is not a fact that after that my husband became seriously ill and could not move properly. It is not a fact that I adduced falsely against the accused. Hmm. PW3 is the son, my lord, of the victim,
Hmm.
Ahmed Reza Chowdhury. Page 17. Chief,
Yes.
PW1 is my younger sister, PW2 is my mother, accused Farooq Ahmed is my uncle. We all reside in the same homestead in a separate house. Other uncles also reside in the same homestead in separate houses. About 3 years back, at one morning, at about 6:30 a.m., hearing alarm of my mother and sister, I awoke from bed and came out and saw accused Jaina Begum, wife of accused Farooq Ahmed, was handing over a spade to accused Farooq Ahmed. After that, accused Farooq with that spade inflicted injury on the head of my father. At the same time, other accused person, namely Sabir, Iqbal, Jaina, started to assault my father with lathi.
Now, come back to PW1 when this Ahmed Raza Chaudhuri was mentioned. Where? Which part?
My lord, PW1 says that I was hearing the conversation between the victim.
No. I am asking specifically about PW3's mention.
Page number 10, cross-examination.
Which part?
At the
Ye-
time of taking to my father, I was along with my brother Ahmed Raza Chaudhary.
My lord, age witness is not mentioned, but
Taking my father to Karimganj.
yes,
But in the chief presence of PW3
It's
Not
not there.
was not indicated.
Not there.
not mentioned,
Only
Huh?
6, 5, and 4.
Huh?
Hmm.
not
But
mentioned.
taking
Presence
the
of
father.
PW3 was not indicated.
Only while taking his father to the hospital.
Yes.
Otherwise, also, my lord, in cross, he said that hearing cry of my mother, and said, I walked from work and noticed 4-5 persons.
No, in the PW1 did not indicate presence of PW3 at the
Yes.
time of the incident.
Actual
In the
accident,
chief.
yes, ma'am.
In the cross, she mentioned that she along with her brother
Took to the
took
hospital.
the injured to
Yes.
the hospital,
Yes, ma'am.
right?
Right, ma'am.
And so far PW2 is concerned, page 13,
My lord.
she says, hearing last line,
My lord.
page 13,
Yes, my lord.
hearing hue and cry, my son, Ahmed Rajat came there.
Yes.
Seeing him,
Accused person
accused person went away.
went away.
But in his cross, in his chief, he says, I saw accused Zaina Begum, wife of accused Farooq Ahmed, was handing over a spade to accused Farooq Ahmed.
Yes, ma'am.
Come back to PW2 again,
Ma'am.
page 13. Fifth line from top,
Ma'am.
bottom. Seeing the same, my husband came out to save me. Then accused Zaina Begum came there with a spade.
Yes.
Accused Farooq Ahmed with spade inflicted hard on the head of my husband. He then fell down. Other accused persons with a spade, lathi, bamboo, so and so assaulted my husband. Hearing hue and cry,
My
PW came.
son, yes. My son Abdul Razak Ahmed came there.
But in his chief, he says something differently.
Yes. My lord, he says that after AM, hearing alarm of my mother and sister, I woke. My lord, fourth line of the chief.
Hmm.
I awoke from the bed He admitting that my lord, he was not there. After hearing the hue and cry of his mother and sister, he awoke from the bed.
But PW1 says with the arrival of PW3, everybody fled.
Yes.
There is one judgment saying while appreciating eyewitnesses, if one eyewitness doesn't speak of the other, is not fatal because at that moment that he might not
No,
see.
we are not deciding about the thing. We are
Yes.
finding out only what one is
Hmm.
saying. We are not jumping the gun here.
Yes, yes.
The link, my
We are trying to analyze what he
Appreciate,
is
yes,
saying.
yes.
We are not drawing conclusion from them
Yes. That.
because something has to be first,
Registered. Yes.
is to be registered.
Hmm.
Analysis comes later. We are only up to PW3.
Yes.
Yes.
So don't make your final submission.
I woke from the bed and came out.
Because
and-
I am very
Yes.
slow in putting things across.
That needs to be done.
If I do not say something, then it will not be registered. That is why I am saying. Yes, Mr. Chauhan.
My lord, yes. From third line, my lord, about 3 years back, at one morning, 6:30 a.m. Hearing alarm of my mother and hearing and sister, I awoke from the bed and came out and saw accused Joanna Begum, wife of accused Farooq Ahmed, was handing over a spade to accused Farooq Ahmed. After that, accused Farooq with that spade inflicted injury on the head of my father. At the same time, other accused person, namely Sabir Iqbal Jaina, and started to assault my father with lathi. My father fell down. Hearing alarm, neighboring people gathered to the place of occurrence. And with the help of them, I took my father to Karingam Civil Hospital. After that, my father was referred to Silchar Medical College Hospital, Silchar, and where from he was shifted to GNRC, Guwahati. My mother went with my father to GNRC, Guwahati, along with me. There, my father was under treatment for 7 days. On 12/12/2009, my father expired. Post-mortem and inquest report were done at Guwahati. After that, we brought the dead body at Karimganj, not Crossman. After 40 days of incident, police examined me. He also examined after 40 days. It is not fact that I did not state before the IO that accused Sabir Iqbal Jaina assaulted my father with lathi. In our house, there are 3 rooms. I was sleeping in a separate room, door of which was closed, was not closed. Hearing cry of my mother and sister, I awoke and I noticed 4 or 5 persons there. Among them, Kamru Jama, Abdul Wahid, and Abdul Hussain were there. So my lord, he present there later on. It is not the fact that I did not see accused Jaina Begum to hand over a spade to accused Farooq. It is also not the fact that I did not see accused Farooq to assault my father with that spade. It is not the fact that I am deposing falsely. From his own, my lord, deposition in the cross examination, it appears that, my lord, he was not present at the time of actual occurrence.
He was
Whatever-
perhaps post occurrence.
Yes, yes. Because, my lord, he says that among them, Kamra Jama, Abdul Wahid, Abul Hussain were found. 4 or 5% found.
Hmm.
My lord, PW4
Yes.
is Imrana.
elder brother of my husband.
Yes, this Masuk Ahmed was my elder brother of my husband. Accused person are of my same home state.
Wife of Jubair Ahmed.
Yes,
Jubair Ahmed. Okay, Jubair Ahmed, okay. Hmm.
on the early morning of 6/12/2009, while I was preparing tea, suddenly hearing alarm of the inmate of our home state went out. On my approach toward the place of hue and cry, seeing me accused Iqbal Hussain restrained me, asking not to proceed further. Then I saw Farooq Ahmed holding a spade and Sabir Ahmed was holding a piece of wood. I also saw accused Jaina Begum near to them. I also saw accused Farooq and Sabir were assaulting Masud Ahmed with their spade and a piece of wood. With the other inmate of the house raised alarm. Hearing the same neighboring people gathered to the place of occurrence, which is the courtyard of the deceased Masud Ahmed. Seeing the people, accused persons fled away. I then went to the PO and saw Masud Ahmed was lying, having serious injury on his head, and out of which there was serious bleeding. The injured was taken to Karimganj Civil Hospital by his wife and daughter, namely Sabia Mehboob and others. Injured was referred to SNCH, Silchar, where he was further referred to JNRC Guwahati, where after taking treatment for 7 days, the death succumbed to injury. During investigation, I gave a statement to IU. Ross. On the following morning of the alleged incident at about 10:30 a.m., police came to our homestead and interrogated us. The person, my lord, not supported by other witnesses. I did not see any injury on the person of accused Farooq Ahmed. I did not see Farooq Ahmed being taken to hospital. It is not a fact that I have no dispute with the accused persons. Relating to any road or electricity connection, it is not a fact that I did not state before the IO date. At the time of alleged incident, while I was preparing tea, alarm and came out, and on my approach toward the PO, accused Farooq Ahmed restraining me, asking me not to proceed further. It is also not a fact that I did not state before the IO that I saw a accused person holding a cricket bat and a spade as I deployed. It is also not a fact that
One, what purpose will serve?
my lord,
If these are not marked and put to the IO.
yes. But my lord, she stated that she saw my lord cricket bat.
No, what purpose? From the evidentiary value. It is a suggestion.
Yes,
It has not taken the color or form of contradiction, perhaps.
but my lord,
Has it taken the form of contradiction?
but my lord, in chief also,
No,
so
chief
many.
is there. Chief is there. Whatever is said.
Yes,
But whether it is suggestions which you have put that you did not state before the IO like this, that. She denied.
yes.
Now, what is the evidentiary value? It is not marked.
It is not marked, my lord, but whatever they depose, my lord, before the,
Specific, that part of the statement is not put across this witness. We are learning, that is why
My lord,
we want to put this query to you.
yes, my lord.
If it is not marked and put across, what purpose will it serve? It appears,
Contradictions.
if it is taken as, it is, suppose it is held that the procedure followed is as per 145, 154, 165, then it appears we will have a very good case.
My,
Now, what purpose will serve? Tell me.
my lord, whatever available material, my
Yeah.
lord, on the bail
No,
basis, my lord, we have to
No, no.
proceed.
Because we have to decide subject to what Mr. Ahmed, what do you say, how to prove contradiction?
That aspect is already clarified by our division bench high court in Abdul Qadir's case. And that they have to first put the contradiction to the witness. And then what she or he has deposed before the police, that has to be put before the
First, I think there are 3 steps to it.
Right.
First, that has to be put to the witness.
Right.
If she admits it,
Yeah. Yep.
it is more or less, if she denies,
Then
then that has to be
That-
marked. And in the cross-examination, that has to be there, that part of the
that
state.
part,
Then when the
Ayog comes.
IO is examined,
Yeah.
then that part is to be, because with that part of the case diary and the statement is to be put across him. And if he says, yes, she did state like this, he did state like this, then
Then
it gets proved. But otherwise, you said before the police like this, the witness denies. So at that point of time, it will be a suggestion.
Sir,
And at best, it is a defense case which is sought to be put forward. But it not take the form of contradiction, perhaps. This is my view, subject to your correction. So it is not a fact. Otherwise, if that is exhibited, I think it would have been built up as a very good case for you.
right,
Otherwise, we will not be able to look into that part of the statement. If it is not marked.
my lord.
Now, here is-
similar is the case. of
Because I am
Abdul Qadir.
rehearsing this because I have not,
No, Lordship is ready.
I have not said, you are seasoned
No.
campaigner. 161. Let us see 162. Nor shall any such statement, whether in a police diary or otherwise, or any part of such statement, be used for any purpose, save as hereinafter provided, at any inquiry or trial in respect of any offence under investigation, the time when such statement was made. 162, substantive part of subsection 1. Provided that when any witness is called for the prosecution in such inquiry or trial whose statement has been reduced into writing, any part of his statement, if duly proved means that has to be, before proving, it has to be exhibited, marked and exhibited. Only then, mere oral thing will not do. May be used by the accused and with the permission of the court, that is hostile. by the prosecution to contradict such witness in the manner provided by section 145 of the Indian Evidence Act, and when any part of such statement is so used, any part thereof may also be used in the re-examination of such witness, but for the purpose only of explaining any matter referred to in his cross-examination. So that witness can be permitted to explain also.
yes.
That is there, that has been, I am just reading here. One judgment that can be done. He can also explain
Yes, you can.
why he made
Hmm.
this departure, or he made the departure. That can be explained in re-examination. But here we are seeing that it is only suggestion in this case.
Mhm.
What judgment, Mr. Ahmed?
Is Abdul Kadir.
Give the citation. Okay, continue. Let us continue. PW 4.
February 4th. Here at page 20, man.
Hmm.
Another suggestion, well, it is also not a fact that I did not state before the IO that I saw the accused person holding a cricket bat and a spade as I deposed. It is also not a fact that I did not state before the IO that I and Badrunessa and other inmates of the homestead raised alarm in neighboring people gathered. It is also not a fact that I did not state before the IO that the alleged incident of assault took place on the courtyard of the deceased Masuk Ahmed, and seeing the people, accused person fled away. It is also not a fact that I did not state before the IO that I saw Masuk Ahmed lying with head injury and there was serious bleeding from his head injury. It is a fact that I did not state before the IO about the sending of injured to JNRC, Guwahati, and his death. I adduce evidence before the principal magistrate, juvenile board, Karimganj against the delinquent juvenile Iqbal Hussain. I stated before the IO that from the eastern side of the ghat of the pond, I saw Masuk Ahmed lying with the injuries, and many people gathered there, and instantly injured was sent to Karimganj Civil Hospital. It is a fact that I stated before the IO that subsequently I heard that the first there had been an altercation in between the accused person, Farooq Ahmed, his son Sabir Ahmed, Iqbal Ahmed, their mother, and Masuk Ahmed relating to partition of their homestead land and accused person with a spade, lathi, shala, etc. inflicted injury. Masuk Ahmed, in an unconscious condition, was carried upon the roadside wherefrom he was taken by a vehicle. I cannot say what type of vehicle was. It is not a fact that I did not see the incident and there had been no such incident as I deposed.
You see, what is the relation? Okay,
Wife of
elder brother of my husband,
Yes.
Masuk Ahmed,
Wife of elder brother.
Jubair Ahmed.
Yes. Next, Witness is PW5, Badru Nessa, wife of Habibur Rahman. Disease of this case, namely Masuk Ahmed, was a younger cousin of my husband. His house was adjacent to my house in the same homestead. Accused persons are also of the same homestead. About 3-4 years back, at one morning at about 6:30 a.m., hearing sound, I came out and saw accused Farooq Ahmed, Jaina Begum, Sabir Ahmed, Iqbal Hussain with spade, lathi, chala were assaulting Masuk Ahmed in the common courtyard of both the parties. On my approach toward the IU, accused Iqbal Hussain showing lathi, threatening me, asking not to proceed. Then I raised alarm, calling Imran Khanam and my son Kamru Jaman, who came out and rushed toward the PO, seeing the same accused person fled away. Then I also went to the PO and found Masuk Ahmed lying unconscious, having blood coming out of his mouth. I also saw the wife and daughter of the injured since disease was crying, sitting near the injured. I also saw this son, Ahmed Raja, and brother Abdul Hussain lifting the injured for taking to hospital. Many others also gathered at the PO. The injured was silent, sent to Karimganj Civil Hospital, from where he was shifted to SMCI Silchar and thereafter to Guwahati, where they succumbed to injury, and after 1 week treatment on the night of the incident, police came to the PO and recorded our statement. Cross. It is not a fact that I did not state before the IO that from the back side of my house, I saw a person assaulting Masuk Ahmed on the common courtyard of both the parties. It is also not a fact that I did not state before the IO that on my approach toward the PO, I was restrained by the accused Iqbal with the threatening not to proceed further, and then I raised alarm, calling Imran Khanam and Kamru Jaman, who came out and rushed toward the PO, and seeing them accused fled away. It is not a fact that I did not state before the IO that I found the wife and daughter of the deceased were crying by sitting near the deceased. It is not a fact that I did not state before the IO that I saw Ahmed Raja and Abdul Hussain were lifting the injured. It is not a fact that I did not state before the IO that I saw blood was coming out from the mouth of the deceased. It is not a fact that I state before the IO that I am in my son Kamrujaman time went to the PO, which was Ghat of the pond. And so Masuk Ahmed was lying injured. It is not a fact that I am deposing falsely to the court. In our homestead, there are 2 ponds. One is in the eastern side of my house and the other in the western side. Windsor pond is owned by accused person and the deceased, whereas the eastern pond is an Mali pond of all the inmates and other homestead. Alleged incident took place on the eastern side of the western pond, which is a place on the northern side of the house. Further cross. My house is situated in a position with north-south direction. From side of my house is on the eastern side. PW6, Kamru Jaman. Kamru Jaman, in chief, I know all the accused person in this case. Disease of this case, namely Masuk Ahmed, was my uncle. On 6/12/2009, it is about 6 to 6:30 a.m. Hearing hue and cry in our homestead, I awoke and then proceeded toward the north. Happened to see Farooq Ahmed, Sabir Ahmed, Iqbal Ahmed, Zainab Begum armed with lathi and spade. Farooq Ahmed was armed with spade and others were with lathi. Seeing me, they ran away and I found Masuk Ahmed was lying head injured with blood coming out from his head. By this time, many others gathered in the pew. Masuk was taken to Karimganj Civil Hospital, where he was shifted to SMCH, Silchar, and again he was shifted to GNRC Guwahati, where he succumbed to injury after 7 days treatment. Place of occurrence was common courtyard of both the accused and the complainant and situated on the northern side of our homestead. And there was a pond on the western side of pew. At some distance from the pew on eastern side, there is a big pond possessed jointly by all the family members of our homestead. It was learned from the Sabia Mehboob, the PW1 of this case, that at the time of alleged incident, accused Farooq Ahmed asked Masuk Ahmed for partition of joint family property. On such demand, Masuk Ahmed told that the middlemen who went to Hajj and on their return, property would be partitioned. It was further learned that regarding the same, there was an altercation for that and accused person inflicted hurt. Cross. IO examined me on the date of incident itself and also on the following day. I cannot remember whether I was examined by one officer or two. After that, there was no occasion to meet with any police officer in connection with them, in connection with this case. I did not accompany the injured to hospital. I also did not visit the police station in connection with this case with any relative of disease. It is not a fact that I did not state before the IO that the occurrence took place on common courtyard of both the parties. It is also not a fact that I did not state before the IO that I found accused persons were running away with spade and lathi from the pew. Name of my father is Habibur Rahman. Jubair Ahmed and Abdul Hai are my uncle. Makhan Mia is my maternal uncle. I cannot remember whether I found all the accused persons at pew. After my reaching at the pew, hearing my alarm, around 12 noon, number of neighboring people reached the pew. I found my aunt Sajida Begum and Piyol along with his son, but there were no other neighboring people. I cannot remember whether I stayed before the IO, that on my reaching I found many villagers were there at pew. It is not a fact that I stayed before the IO that I found Masuk Ahmed lying on the ghat of the pond in a senseless condition. It is not a fact that there had been a dispute with the accused person regarding a path. I cannot remember the name of the person whom I called at the time of alleged incident. I did not notice any injury mark on the person of accused Farooq Ahmed and also did not see whether he was taken to hospital. I cannot remember the name of the person who along with will be carried the injury for boarding a car. Around 1.5 cubic place of ground was smeared with blood and on the pew. I cannot say the accused person in which direction they ran away, seeing me. Nobody chased them. I cannot say subsequent conduct of accused Farooq. It is not affected. I did not see the accused person on run from the pew. It is not affected. I did not see any of the accused person with any type of arm as I depose. It is also not affected. I did not find Masud Ahmed lying in the courtyard. After 2-3 minutes of my seeing Masud Ahmed is lying, I along with others carried him up to the road. PW7 is the doctor from GNRC.
Yes.
On oath, I have entrusted to depose on behalf of GNRC Hospital of all court matters. On 7/12/2009, I was posted in the GNRC Hospital as senior consultant neurosurgeon GNRC. On that day, the patient Masud Ahmed Choudhury was admitted in our hospital with history of alleged assault on 6/12/2009 at 7 a.m. in Karimganj. He was unconscious since the alleged assault and he was initially treated at SMCH. He was making incomprehensive sound and movement were abnormal and extensor. CT scan of brain revealed bilateral, frontotemporal, parietal, epidural hematoma with mass effect and surface sign herniation of right frontal lobe to the left region. Multiple contusion in both the side of brain. Supranual hemorrhage in right parietal region. Diffuse brain swelling with impairment of basal system. Commuted fracture in left frontal and temporal bone with involvement of superior orbital margin on the left side and depressed linear fracture on the right temporal bone. He was treated with medicines and mechanical ventilation. His condition gradually deteriorated and expired on 12/12/9 at 10 p.m. Dr. N. Barua submitted the discharge summary of the patient Masud Ahmed. Exhibit 4 is the original report of and Exhibit 4.1 is the copy of the report, probe in original. Exhibit 5 is the medical certificate of death issued from GNRC by Dr. Hawk. The patient was admitted under Dr. Navanil Barua. Dr. Navanil Barua is working at present in the GNRC Guwahati. It is not affected. The patient was admitted by Dr. Manjural Hawk. The patient was initially treated at Silchar Medical College Hospital. Thereafter, he brought to GNRC. There, in a discharge certificate from SMCA, is conservative under the headline treatment, which means he was conservative under treatment. The patient was admitted in GNRC on 7/12 and he died on 9/12/12. I cannot say whether Exhibit 5 was seized by the police or not. In the SMCH report is also mentioned thoroughly the number and the type of injury. The SMCH report depicts head injury and cranial candual injury. Exhibit 5 The injury described in the increased intracranial pressure due to head injury is cause of death. We have not given the Exhibit 5 to the police because we have not supposed to give the same to the police. There are 3 doctors in the group who have given their signature in the report, namely Dr. N. Barua, Dr. R. Chaudhary, and N. K. Das. This report 5 was not signed by R. Chaudhary and N. K. Das. It is not affected as this report is not genuine. So R. Chaudhary and N. K. Das have not given their signature. It is not affected. I have submitted the Exhibit 4 on my own interest. The IOE PW8, Beni Madhav Dev. Smile, please.
Yes.
Uh, On 7/12/2009, I was posted in Karimganj Police Station as Sub-Inspector of Police. At that time, Sri Uday Shankar Gupta was the officer in charge of Karimganj Police Station. On that day, one Sabia Mehboob Chaudhary had lodged a written first information leading to registration of Karimganj PS case number 524 2009 under section 354, 323, 326, 34 of IPC and had entrusted me with the investigation thereof.
Okay, we'll resume it.
Yes.
Outside bail.
My lord, jail.
They are in jail.
Yes.
Since when?
Since my lord last
Mhm.
1 year in Malpan. Since the jail.
22. Judgment
Yes.
is of which state?
Yes. Yes.
Okay, 1.5 years. Hmm?
3 months, yes.
3 months.
Yes.
Now, my lord, only these 3 women join us as a career condition. In a goal at any moment. That is happening. So there was just good information. So there also is a admitted in the hospital. On the day.
My lord, we are going through my lord PW8, the IO, my lord, Benu Madhav Dev. On 7/12/2009, I was posted in Karimganj Police Station as Sub-Inspector of Police. At that time, Sri Uday Shankar Gupta was the officer in charge of Karimganj Police Station. On that day, one Sabia Mehboob Chaudhary had lodged a written first information lodging to leading to registration of Karimganj PS case number 524/09 under section 354, 323, 326, 34 IPC, and had entrusted me with the investigation thereof. Exhibit C is the printed form of the FIR. Exhibit 6(1) is signature of the Uday Shankar Gupta, which I know. On taking up the investigation, I opened the case diary and examined the informant who was at the police station. Thereafter, with him, I went to the place of occurrence in village Kanisail on the eastern side of the pond belonging to the disease. I prepare a sketch make of the place of occurrence by Exhibit 7, wherein Exhibit 7(1) is my signature. Then I recorded the statement of witnesses. I recover one spade with bat measuring 3 feet and one piece of wood measuring 2 cubic in size and same by Exhibit 2, wherein Exhibit 2 is my signature. I took signature of the witnesses to the seizure thereon. The said material were shown to me by the informant. I recorded the statement of seizure witnesses. From the informant, I could know that the injured victim had been taken to Guwahati for a treatment, and accordingly I sent a request message to the officer in charge of the dispute PS for recording the statement of the victim. On 12/12/2009, I could know from the police dispute PS over phone that the injured Masud Ahmed Chaudhary had died at GNRC hospital at Guwahati due to his injury. The dispute PS had got inquest conducted over the dead body and also got the autopsy. Further examination. I had received the subsidiary case diary from the dispute PS. I had collected the autopsy report of the victim. I also arrested the accused. Along with the subsidiary case diary, I had also received several documents from the dispute police station. Exhibit 8 is the letter forwarding the dead body of the to Guwahati Medical College and Hospital for autopsy. I had also received several documents of GNRC Hospital at Guwahati from dispute police station. Dr. Manjurul Haq, a junior resident doctor of GNRC, had informed dispute police station at Exhibit 9 that the injured Masud Ahmed Chaudhary had expired on 12/12/2009. I had submitted the charge sheet by the Exhibit 10, wherein Exhibit 10(1) is my signature. The X, here my lord, I have mentioned X. The X with 3 feet long bamboo handle and 1 cubic long wooden pitch, seized by Exhibit 2, corresponding to Mr. MR number 258 of 2009, is seen in the court. I identify them as material Exhibit 1. So my lord, in court, X was exhibited and shown. Close. Next page 29. I started investigation on 7/12/2009 at 1:10 p.m. I was entrusted with the investigation by the concerned officer in charge on the same day, on 7/12/2009 at 1 p.m. Prior to receipt of the FIR, I received an information later on. Deported, I did not receive any information prior to FIR. The distance between the Karimganj police station and the place of occurrence, which is at Kanisail, is about 4 kilometers. Karimganj police station and the Karimganj civil hospital is about 1.5 kilometers away. As per the FIR, the alleged occurrence took place on 6/12/2009 at about 6 to 6:30 a.m. There is no explanation mentioned in the FIR regarding delay. I have not examined the writer of the FIR. I have not collected medical report during the investigation.
Yeah.
I have not sent the victims to any hospital for medical examination. During the investigation, I have not collected any report from GNRC. It is not a fact that I collected any medical report of Masood Ahmed Chaudhary from GNRC or submitted the same along with the same bearing page number 26. I do not know if any medical report mentions in the injury of the victim to be accidental. It is not a fact that I collected any medical report of the victim from Karimganj Civil Hospital or any medical report mention the alleged injury to be accidental. Page 30. It is not a fact that no FIR was lodged after the incident. I have not collected any document from Dispur police station. I have not collected any history of treatment from GNRC. It is not a fact that I have not collected any history of treatment of the disease from GNRC with the intention of concealing the fact that the disease had any surgery on his forehead. I have not examined the driver of the vehicle by which the disease was taken for medical examination. I have not prepared any sketch map regarding the stair of the concerned pond. I have not seen blood clotted cloth or blood coated soil from the place of occurrence. I have not seen any blood-stained weapon, though I have seized a weapon, a spade. Material Exhibit 1. I did not come to know regarding the owner of the seized weapon during the investigation. It is not a fact that the seized weapon was not used in the alleged offense or it did not belong to the accused. I have not recorded the statement of the doctor of GNRC. PW1 Sabiha Mehboob Chaudhary did not state before me that after the alleged incident, when the people started to come near to the place of occurrence, the accused person restrained them. She also did not state before me that after the incident, Abdul Hussain, Kamru Jaman, Badru Nisa, Imrana Begum, and many others came just after the incident. PW2 Sajida Begum Chaudhary did not state before me that at the time of incident, I was near to my husband on the door and hearing conversation. My daughter Sajida Khanam Chaudhary also came. She also did not state before me that seeing the same, she went out to register the accused, Farooq. Then all the accused person, namely Farooq,
Mr. Chauhan,
Mal,
these accused persons did not deny their presence at the place of occurrence.
Malad. In 313 Malad, he stated there was mal physical touch.
They are trying to say that it happened near the ghat.
Malad.
And this Farooq Ahmed, he tried to project that the disease had some illness and he fell
Well,
near the ghat or the
Yes.
stairs.
Mm.
That is what his projection is. But his son said both his father and the diseased, he found both of them lying
Yeah.
on the ground.
Yeah.
And he found a head injury
Malad.
in the backside of the head of the deceased.
Mm.
He has candidly said that in the 313 statement.
But 313
So the presence of these accused persons at the place of occurrence was not denied
But my lord,
by themselves itself.
presence of accused person, my lord, PW1 said, my lord, the first, my lord, this is the appellant number 1, Farooq.
No,
Then, my lord,
I am saying our presence.
presence.
Presence of all the 3 accused persons were not denied by them. They have themselves in their 313 statement.
But my lord, also a contradiction about their presence at the time
No,
of exact occurrence.
Question, I'm simply saying that presence of the accused persons at the place of occurrence was not denied by them. They had admitted that they were there. And how the incident had happened, that is one matter. But their presence were there. And it is within the same
Courtyard.
compound.
Compound is.
They have a common pond also.
Yes.
Both the families use the common pond, right? And the deceased who sustained injury on that date,
Mm.
that is also admitted by AW Sabir Ahmed. He was found lying along with his father with injuries.
Yes.
Now, so far contradiction is concerned, though you have exhaustively cross-examined PW1, PW3, 1, 2, and 3, that did not materialize perhaps into contradictions.
But my lord, PW1 and PW2, they claim, my lord, PW1 claim I was there hearing the conversation. Then, my lord, abuse were
I
there.
am not into that part. First, what are disputed or not disputed? You have exhaustively cross-examined PW1, PW2, and PW3
Mm.
regarding their referring to police statement.
Mm.
But it did not materialize into any contradiction. What do you say about that?
My lord, it appears so, my lord, because the trial court, my lord, conducted.
Regarding inconsistencies between PW1, PW2, PW3, we'll discuss later.
Yeah.
But so far as your exercise to elicit contradiction perhaps had failed. What do you say about that? With regard to PW1, PW2,
So, my lord, the
head
contradiction.
injury, there was head injury. It is established. How he had sustained head injury, that is one matter.
My-
But the injured sustained a head injury.
my-
That is also established,
Medically proved.
medically proved. How it had happened, it is one matter. But so far, had your case been successfully followed by establishing the contradiction, proving the contradiction, it would have been completely different matter. But that is not there. What do you say about this?
It is right.
Which I said
But,
directly to you that your contradiction is not established.
my lord, it appears so, my lord, but my lord, since my lord 161 is not marked or not my lord, exhibited, my lord, that part, my lord, what is stated in 161, my lord, whether,
It is not a piece of evidence.
yes,
So we have to put aside, keep aside all these statements in the cross exam. It is not a fact that I did not state before the police.
these are
That part we have to
suggestions,
leave aside.
these are mere suggestion, my lord.
Suggestions. Only.
Yes,
Then let us concentrate on the substantive part of evidence.
yes.
Chief,
Hmm.
could you elicit any contradiction in the cross examination? Could you elicit any?
Substantially no contradiction, but a little contradictions are
Well,
there.
leaving aside that part, I did not state before the police.
Yes.
Any other contradiction from the cross examination? I could only see that PW2 saying that there was a scuffling. PW1 also saying that scuffling. PW2 also saying that there was not very much of an altercation.
Hmm.
Then she said also that the accused perhaps in a spur of moment
Yes.
inflicted the
Yes,
injury.
my lord, it is, my lord, this goes to show, my lord, only appellant number 1 is
So
involved.
she did not get any scope to restrain.
So
If-
far, my lord, appellant number 2
So
and
far-
3, my lord.
Sustaining injury by PW1 and PW2 could not be conclusively proved.
Not proof, my lord, it is mere statement. Not,
Let us
not,
let
not-
us analyze the
Yes,
points.
yes, yes, my lord.
Perhaps though they said assaulted may not result into injury, but there could be assault.
But my lord, so far, my lord, assault of my lord, the victim by several weapons, my lord, medical does not support it. Medical, my lord, only, my lord, this head injury. Only head injury.
And
No,
about,
no lathi,
about
bamboo.
Joina Begum handing over the spade to Farooq Ahmed.
My lord, kindly see, my lord, then FIR, my lord. See what, my lord, this the spade was lying in the courtyard. From courtyard, it was taken. My lord, page 4, my lord, last 4 line, my lord. Then my father came out of the house and he asked accused, number 1, why he was assaulting with the letter struck my father in head with the who and was lying on the courtyard.
So-
So
It could be a case which has developed spur of the moment, could be. There was discussion. Even Farooq Ahmed said there was some discussion
Mm.
in his 313 statement.
yes,
Meaning there was some conversation was going on between Farooq Ahmed
conversation, my lord, had
and
my
he had a pawn.
yes. And
That is established.
PW1 and 2, all my lord, admitting that there is, my lord, dispute regarding partition of land. And regarding debt partition, there was a talk. Or
And
my
these
lord,
witnesses otherwise leave aside 1 to 3. Right?
my lord.
These PW4, PW5 and PW6. Those witnesses were related to you as well as to the
Right, my lord. Then,
right.
because my lord, both
They
the-
were related
right.
to both the families.
Yes, sir.
The
Well,
accused family as well as the deceased family.
In fact, my lord, from the same family, my lord.
The same family. That is
Yes.
what living in the same compound.
Yes.
And this
And victim and my lord, the appellant number 1, same father.
same father.
Yes.
That is what I am saying.
Yes, my lord.
that PW1, PW2, and PW3 are from the same family.
Well,
And these accused persons are all from the same family. Right? Farooq Ahmed and deceased were brothers,
Mm.
right?
mm,
And this PW4, PW5, and PW6,
also
Right.
related, also related, my
are
lord.
very related.
Yes.
They are as near a relation
Yes.
to you as well as to the deceased.
Right.
Badru, PW5 was the son of, PW6 is the son of PW5.
Yes.
Oh, sorry. Badru, no. Zubair Ahmed. I think he's one of your brother,
Yes.
Farooq Ahmed's brother.
Yes.
This Badrunessa, wife of somebody. So all are related.
Yes.
Same, by
Right.
the same relation, first
Right.
degree.
Yes.
So why should we disbelieve their evidence? Whatever substantive evidence.
My lord, exact occurrence, my lord, only my lord PW2 claimed that, PW1 claiming that she was, my lord, present at the time of Tasul, and hearing, my lord, even crime, her mother came out from the home, and mother was assaulted. Then her father also came out, and father was attacked by appellant number 1. This PW1. PW2 is saying that I was present and I was hearing their conversation. Thereafter, her daughter, that is PW1, came later on, and thereafter the victim came.
It is not a different place than their house and compound. So their presence could be very natural. Their presence, had it been some other place, we could have said, but presence of wife and daughter would be
Well,
very natural.
Came out from house.
And 6 o'clock morning.
Came out from house, my lord, it is stated. And PW3, my lord, is
Because
the
you have
son.
not been
He
able
was
to
my lord.
demolish PW1 and PW2.
And PW3, my lord, he was his son. And after my lord hearing him cry, he woke up and then he,
But you have not been able to demolish or shake the credibility of PW1 and PW2 perhaps. Their sequence appears to be. Is there any factor
My
which
lord,
you appreciate because of the delay?
delay is also, my lord, 30 hours. 30 hours
No,
delay.
about examining them. When
But
did
yes,
they were examined.
examining by IO.
Huh?
IO. Yes. IO long, my lord, delay in recording their statement. Even 164 statement also recorded after 40 days. And my lord, from the FIR, it appears that, my lord, this only appellant number 1, the spur of the moment he attacked. But so
That
far
is
the
what
appellant,
PW2 said.
yes. PW.
PW2 says that
PW2 is the fifth line. At the time I was near to my husband on the door, hearing conversation, my daughter Sahiba Mehboob Chaudhary also came. At the time when my husband went to return back home, accused chased my husband, uttering slang languages. However, my husband entered into the house. But the accused, finding my daughter, started to assault her. Seeing the same, I went out to resist the accused Farooq. Then all the accused person, namely so and so, assault me. She says, my lord, she was the first person who was hearing the conversation, and after conversation, Hearing the conversation, her daughter, that is PW, came out from the house. And my lord,
Is there any alternative submission? Let us be clear.
my lord, so far the appellant number 2 and 3, my lord, from going through, my lord, the FIR, all this, my lord, their involvement not proved. Because, my lord, the medical evidence also says one, my lord, injury. One injury. So, my lord, and seizure, my lord. Kindly see, my lord, the encroach, my lord, the IO says, my lord, he sees X, not a spade or who.
Mr. Chauhan, that will not help you because that will not help you much because of the fact that IO, right? IO. See, page 28. Just before bold letter. The acts with him, but he is thinking, I don't know, but the axe with 3 feet long bumble handle and 2 cubic long wooden piece seized by the exhibit 2 corresponding to MR. So and so is seen in the court. I identify them as material exhibit 1 collectively. If he identifies the spade as X, that does not mean, but he has identified in the court.
My lord, I identified, my lord.
If he says that as X, it does not become a spade become an X. He has identified it as material exhibit.
But my lord, my
That
humble
will
sub-
not give
my,
any
my humble
assistance to
submission,
it.
my lord, the person who saw, my lord, the claiming
Is there any, I'm asking you, is there any
my lord, my
other
lord,
submissions?
my lord, my lord, took, my lord, this spade and, my lord, wooden piece. Next day, as shown by the grandfather of the informant. My lord, that means, my lord, I took no doubt, my lord, see.
Grandfather, that gives more weight. Who said grandfather?
My lord is a PW1.
Grandfather.
Yes.
Grandfather is handing over the
Yes.
things to
Spade.
police.
Spade. And my lord, this
And by that
wooden
way,
piece.
his 2 sons were involved in the altercation.
Yes.
Had he been some other thing, other man, I could have understood.
Kindly see, my lord. 106 piece. He is part of his husband. Call number here. C.
10?
106. Material exhibit. For court found. What is spread over X?
Material exhibit. He is
Court exhibit. C.
showing material exhibit. This has to be read together. That man had identified. Had you confronted with that? He had identified in the court. Page I have already shown to you.
My lord, a PW1, my lord, claiming that she saw the, my lord, attack. But, my lord, prosecution not produce, my lord, this weapons, my lord, of offense. Before, my lord, is the PW1, also before the PW2, my lord. Who can, my lord, rightly say it before the court that these are the, my lord, weapon used? Not. I, my lord, I is not eyewitness, my lord. I sees, my lord. But, my lord, most important witness is the PW1 and 2. Before them, my lord, prosecution did not produce the, my lord, the weapon of offense. And proved by man, these are the weapons that the victim was attacked.
Now, come to that part. IO. That was in page 28. Right. He said X with 3 feet long bumble handle and 2 cubits long wooden piece. Seized right exhibit 2.
Exhibit two
Exhibit 2
says
is Caesar list corresponding to MR 258 of 2009 is seen in the court. I identified them as material exhibits or material exhibit number 1 collectively. Now come to the Caesar list.
Caesar list, my lord, is
Come
correct.
to the Caesar list.
Yes, ma'am. 108.
108. Now here it is hoe with a handle
Yes, yes.
about 3 feet in length and a piece of wood.
Who and X is completely different weapon, my lord.
That is our only submission.
My submission is that, my lord, the base witnesses would have been, my lord, PW 1 and 2, who claims, my lord, by using that weapon, my lord, attack assault was there. My lord, but prosecution not, my lord, produce in court while, my lord, their evidence was going before the PW 1 and PW 2. And also, my lord, before the doctor, because doctor, my lord, can say, yes, such type of injury may be caused by, lord, such type of weapons. So these are the 3 vital witnesses, my lord, to substantiate that, yes, this may be the weapon which caused such type of, my lord, injury. So no, it is not before, my lord, doctor, not before PW1, not before PW2. And IO, when, my lord,
What kind of injury he had sustained, that has been said by PW7. And PW autopsy doctor has said that it is the opinion of the treating doctor which should be material. So treating doctor is PW7. Autopsy doctor says it will be the opinion of the treating doctor which should be material. Treating doctor says multiple conditions in both sides of brain, commuted fracture in left frontal and temporal bone, depressed linear fracture of right temporal bone. It is not on the left side. It is also on the right side. Have you gone through this?
Yes, page 25.
And autopsy doctor in page 35 says it is the opinion of the treating doctor which will be material as regards the whether it is a case of homicidal or not. And it is not that he says all injuries, but main injury is on the left frontal temporal region,
My lord,
but extending to up to right temporal bone also.
my lord, postmortem, my lord, is a page
I have gone through.
127, my lord. Injury, my lord, serial number 2, wounds, position and location. Stitch wound of size 2 centimeter into 2 centimeter into scalp deep presence over the left side of the forehead, 4 centimeter from the right and 14 centimeter above the left. The process. And wound is repaired by 3 surgical stages. So, my lord, this postmortem is for 1 injury. Injury. Injury, wound of
You have to dissect it properly.
at page 128, I am reading. External appearance, serial number 2.
Any
wound.
other submission? This doctor postmortem doctor says all injuries were antemortem and were caused by blunt force impact. And he says, as the disease was undergoing treatment in the hospital and died during the treatment, it is difficult to give a final opinion as to whether the date of the disease was homicidal or not. For the said purpose, the opinion of the treating doctor is required to be taken. That is the answer.
Yes.
Now let us see the inquest report. 134.
134.
Postmortem report does not indicate there is only one injury. It appears to be maybe in the main head region, but left, right, both are there.
Mm.
He says only one injury.
Yes.
Forehead.
What else?
That cannot be denied now. Now, one injury cannot be denied.
One injury, my lord.
It cannot be denied.
The appellant number not denying. His, my lord, defense is dead. While, my lord, regarding dispute, my lord, the physical tajul was there, and both of them, my lord, in 313 he's saying, both of them, my lord, they fell on the staircase of the pond, my lord, and both of them sustained injury. And my lord, this Masuki is also sustained
Come
injury.
to page 36. You have elicited everything. That submission false. Come to page 36. Cross-examination. It is not likely that the head injuries sustained by the victim would have been as a result of the fall on stony surface. Mr. Sohan,
It is not likely.
take
that-
everything into purview, then make the submission. If it is a case of fall, it would have been a different thing. Second part also. Cross-examination.
Yes, my
It
lord.
is not likely.
Yes, my lord.
You have elicited from the postmortem doctor, autopsy doctor. So it is not a case of fall.
Mm.
That is why there is no yes.
My lord,
Any-
one last submission is there, my lord. A cross of PW2. Cross of PW2. My lord, she clearly stated accused in a spur of moment inflicted the injury.
That I have already said to you from my side. I had said.
Yes, sir.
You have not shown it to me. I had said that's part of the moment.
And
So that is why I have been asking you something.
that shows, my lord, the appellant
I
number
expected
2,
yes.
appellant
nothing
number
is-
2 and 3.
Nothing is coming.
Trying to put the words in.
My lord, this is the appellant number 2 and 3. My lord, not involved. And so far the appellant number 1 is, my lord, it may be case of a 304.
How? Why 34
Because, my
should
lord,
be?
it-
Why 34 should be
Because, my lord,
kept out?
PW2, my lord. PW2 herself stated, my lord.
No, that is okay. Now, why 34 is to be kept?
34, my lord, because my lord, FIR, the first, my lord, who is my lord herself claiming that the eyewitness? Only is my lord, my lord, is
FIR
FIR.
is not required to be an encyclopedia, but they.
No, no,
he had-
not
he had
exactly one,
mentioned-
my lord, but she is my lord, he's claiming to be eyewitness. And she is my lord, doing her graduation, my lord. She is not illiterate lady, my lord, or girl. So, my lord, she.
Yes, you can start the opening of her.
In fact,
Let-
it's the case of 304, if I may say. Because part of the moment, secondly, he died after so many days. And one injury cannot be ruled out.
This submission is coming from the prosecution side.
Taking both the sides into account. Because otherwise the homicidal death is good. Even if we say that there are contradictions, but PW1 stands. PW1, the contradiction is not in relation to the actor seeing the incident. PW1 is very consistent. PW2, even if we consider 2, 3, 4 contradictions are valid. And one eyewitness would be enough. As far as the incident, as far as the homicidal death,
So for the place of occurrence, there is no doubt that he sustained the head injury near the pond inside the compound. That is established.
Some say that.
Second thing is established that the houses of both the families, along with the other PWs, that was within the same compound. Then presence of PW1, PW2, and PW3 at the place of occurrence is very natural. And injury is homicidal. It is not a case of fall as projected.
The second statement also makes it. clear that-
Doctor from GNRC as well as from the autopsy doctor, it is a case, not a case of fall. It is a case of assault. Question is what kind of assault it is. And plus whether 34 would be applicable or not. Perhaps this is the view of the tentative.
Communication can be built in that part of the document.
That would be, but otherwise it is PW2 says part of the amendment. There was conversation.
There was a problem.
Suddenly it may turn out to be a case of assault, but it is not a case of fall also.
And in one.
This is the difficulty. It is a conversation, quite conversation between two brothers about some land dispute. It can happen, natural, then suddenly one may become angry.
and the
But
mindset
it is not a case of, though it is it projected scuffling, it is not there. So if it is not there, it is a case of assault. So case of assault, only what we mean is that kind of assault.
Actually, my lord,
Because of the because the date occurred after few days. That is one. That is one mitigating circumstance. Second, PW says it is a spur of the moment. FIR also says. So this is these are the
Cannot be ruled out. One place. In fact, the doctor had said, had it been a fall, there would have been other injuries. There are no other.
yes.
My lord, actually, to speak the truth, this is the case of 304 part 2.
That is what
Yes,
since last 45 minutes I was Mr. Sohan is not
Inclined. What secretary is made.
that is difficult, which is not
so
What else?
our 304 part 2 case, the maximum conviction is 10 years. So
Maximum is life, but minimum is 10. Anything from
maximum 10 years.
part
Say,
2.
Yes,
Part 2, like
10 years. 10 years.
public intentions are.
So
we have
my
to
lord,
see get one authority will
considering
start at
considering the
tomorrow.
age,
Will dictate.
Tomorrow.
Will dictate tomorrow. Find out what kind of 30 4, which part? How? That, Mr. Amit, you assist.
Because it's a vital part of the body, so knowledge.
Then it is part 1.
Huh?
Then
Oh.
about 34? What about sun?
He has no involvement, ma'am.
No, I'm just we'll scan again.
Common intention has to be gathered from their conduct immediately before, during, after. So here son immediately came with Lathi, the wife. She had given the spade. So
Okay.
these actions to
Find out 304, part 1 or part 2. We'll see tomorrow.
This where it's comfortable. But
Heard Mr. B.B. Najari, Senior Counsel. Assisted by Mr. S. Chauhan, Learned Counsel for the Appellant. We'll hear Mr. Ahmed tomorrow. S. Jahan, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, and Mr. A. Ahmed. Mr. A. Ahmed, Learned Counsel for the respondent number 4. 2 is to make submission tomorrow. At least the case. We'll take up at 2. Let the other cases be over.
Ramadan month is looking on.
True.
Yes, you'll be there. If other cases are over, I will take up. Raise the case tomorrow. Yes, Mr. Gupta. Have you gone through?
Yes, my lord.
Day after tomorrow?
My
then?
lord. Item 3, yes.
Day after tomorrow.
My lord.
Huh.
I was.
H. Gupta. Only the wife's evidence.
One PW, one is.
She said, I did not see my daughter. Had it."
Depending upon your submission. H. Gupta, Learned Amicus. Amicus.
My lord.
Amicus for the appellant and S. Jahan. Release the case day after tomorrow. 14th. We'll take up that first. Now I have to rise because of some other engagement.